and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. What have you been doing since I last saw you?
Well, we did a course this morning on adverse possession, which is very timely, actually, because we're talking about a Supreme Court case on adverse possession from yesterday, as we were recording, 26th of Feb. It's Brown and Ridley, which is a familiar case because we did a podcast on it when it was at the upper tribunal last year. So, yes, I've lots of adverse possession with you today. So do you want to start by telling us why this one went straight to the Supreme Court and didn't go to the Court of Appeal?
Quite a rarity, really. It's what's called leapfrogging, because obviously the next Court of Appeal after the upper tribunal is the Court of Appeal. But if it's deemed to be significant and an important decision, you can leapfrog the Court of Appeal and go straight to the Supreme Court. For reasons we'll see, it would actually be quite difficult for the Court of Appeal to hear it because it seems to conflict with other Court of Appeal cases. But I thought it was leapfrogged because of its significance. And it's not every day you get a Supreme Court case on adverse possession. I think the last was 2002, I think.
So do you want to tell us a bit of the background law to adverse possession to set the scene?
Yeah, it was a registered land claim. The law in adverse possession changed a lot in October the 13th, 2003, when the 2002 Land Registration Act came into force. Prior to that date, you could claim adverse possession. You can still in unregistered land after 12 years adverse possession. In registered land, if your claim arose before October 2003, you can still claim after 12 years. But for new claims post or from October 2003, it's a 10-year period. You apply to the land registry. It's something called an ADV1 application, and the land registry gives notice of adverse possession to the paper owner of the land, the registered proprietor, who's got 65 working days, 13 weeks to object. And if they do object, then the applicant has got to show one or more of three types of adverse possession apply. And that's basically what it's about. It was the third type of adverse possession which was being discussed, which is the most common method of claiming of them all.
So what are the facts of this case then?
Yeah, as you mentioned, we did do it, I think it was last spring when it was at the upper tribunal. It all took place in County Durham, Consett, in Durham, on a road called the Promenade. Brown had purchased this piece of land in September 2002. And Mr. and Mrs. Ridley had purchased a piece of land that seemed to be backing onto Brown's land in July of 2004. And they initially both seemed to have assumed that a fence that predated their ownership, a fence and hedge at the end of the Ridley's land, bordering the Brown's land, was the border, the boundary, when in fact it was some way within the fence itself, and some land up over on the other side of the fence should have been Mr. Brown's land. Nothing seems to have happened until it was February of 2018. They both seemed genuinely to have thought the fence was the boundary and the hedge. February 2018, Mr. and Mrs. Ridley put in a planning application and got planning permission to build a house, on their land, which would go and cover the land where the fence was, before where the fence was. And they started the building work in October 2019. Mr. Brown objects to this and basically claimed originally what seems to have started the application off that they were breaching the Party Wall Act, the 1996 Party Wall Act, which is all about notices if you're going to do excavation works, amongst other things, close to the boundary line. And so they looked into it, found that perhaps it wasn't their land after all. They'd already built the house and were moving into it to live there. But they, in December of 2019, they put an application with the land registry for adverse possession, which Mr. Brown objected to. And so they claimed one of the three types of adverse possession, which is necessary for registered land claims since 2003. Shall I explain what that is?
Yes, please.
It's where there's a reasonable mistake as to boundaries. There's sort of four requirements, really. Firstly, the applicant has to have land adjacent to the land where the application refers to. And secondly, there's not been a determination of the boundary by the land registry. There's a general boundaries rule, which people forget about, the Section 60 of the Land Registration Act. The file plan doesn't necessarily tell you where the boundary is. It's just a general indicator. But you can apply to the land registry to joint application to determine the boundary exactly. But that hadn't happened here. Thirdly, there has to be a reasonable mistake as to boundaries. It's all in paragraph 4 of the Schedule 6 of the Land Registration Act has all this in it. But there's going to be reasonable mistake as to boundaries. And fourthly, then you can't claim a reasonable mistake as to boundaries unless you've have been registered as proprietor of the land for at least a year. 3 of those requirements have been met, but the question mark is over the reasonable mistake as to boundaries. Have you for 10 years made a reasonable mistake as to boundaries? There'd been, I remember mentioning this when we mentioned it up at tribunal, the problem was that there'd been a couple of Court of Appeal cases, one called Zarb and Parry in 2011, and another called IAM Group and Chowdhury in 2012. And they both said that the claim, the reasonable mistake as to boundaries, there seems here to have been a reasonable mistake as to boundaries, but the claim has to be for the 10 years before you make your application. The first tier tribunal, when they heard it, I mean, basically they made the application to the land registry and the land registry referred it to the first tier tribunal. And they said that the Court of Appeal decisions were only obiter. Do you know what that is, Lizzie?
No.
Obiter is not part of the binding part of the judgment, so it's not within the precedent, it's just advisory, as opposed to the ratio decidendi, but which is the legally binding part. So basically, the first tier tribunal said we're not bound by this. There have been other cases. I remember a case called McLeod and Brown in 2013, where first tier tribunal said the same thing. It went to the upper tribunal, said that unfortunately, it is part of the ratio, and therefore it's binding on its Court of Appeal as a higher court. And reluctantly, they said, because they thought the Court of Appeal were wrong, they said that you have to make your claim not immediately, but promptly after you realise there's a mistake as to boundaries. And that's what we talked about last time. So originally, the Ridleys failed.
So what was the decision then?
Well, when it got to the Supreme Court, it's quite a short judgment. I mean, it was unanimous, but the main person was Lord Briggs was the main sort of judgment, and they said that you have to interpret legislation according to what Parliament obviously intended, and it would just be asking for litigation left, right, and centre. The problem was that they must have realised there was a mistake, in February 2018 when they made their planning application. They would have realised that this wasn't their land in the first place, and it was 18 months later before they make more than that actually, before they applied to for adverse possession. But the Supreme Court said that it couldn't have been intended that you have to occupy for the 10 years previously, because otherwise. And make a reasonable mistake for the 10 years previously, because otherwise, as soon as you realise it's not your land, you'd have to promptly make the application, and that can't be right. And so they basically reversed the upper tribunal decision, which the upper tribunal would have been happy with if truth be known. And any 10-year time period in the past reasonable mistake is the boundaries, as long as you've got adjacent to adjoining adjacent land and there's not a clear determination by the land registry, the boundary is sufficient. They also tried to argue, did Mr. Brown and his counsel, that there's a sort of de minimis principle to it. Do you know what de minimis is?
Well, I know I've used the word, but I don't know if I know what it means in this
It means it's
context.
sort of small. De minimis non curat lex. It's so small that you can
Yeah.
basically ignore it. And they suggested that, you don't have to make an application immediately, but within 1 or 2 months. And the Supreme Court said that that's not the case. There's no authority for that. They also claimed that did Mr. Brown that it would be a breach of human rights if there's any doubt as to the interpretation under human rights and Article 1 of the first protocol of the European Convention on Human Rights, which is all about right to property. It should be interpreted in favour of the person who's the paper owner, and the Supreme Court said that it's not a breach of human rights. There'd been a case, Pye in the UK, 2007, which had said that the Grand Chamber of the European Court of Human Rights, nothing to do with European Union law, but 15 judges on horseback would have, basically said that adverse possession wasn't a breach of human rights. So on all grounds, unanimously, the Ridleys won. And it's quite significant, that if any time in the past registered land claims arising post 2003, all you need is those 10 years at any time in the past, and you might then realize there's a mistake, but you can still make an application sometime later. And that's Brown and Ridley. It'll be the last, I would imagine, we hear of it.
Brilliant. Thank you very much, Richard.
Thank you a lot, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.